So if you have any questions or comments throughout the presentation, feel free to throw them in the chat. I'll even pull people up um, if you have a voice question. But I am very excited to kick this off, this autumnal presentation. I'm very sorry that I know we kind of switched the script. We were working with our partners at Forecaster, which we usually do a regular Thursday webinar, but they're all off in Silicon Valley or San Francisco at the moment, getting together, and they couldn't have the time for it. So we switched this to a Gust-focused webinar, but it's actually a webinar I'm very excited to because it is seasonal. I hope you can all still hear me. Somebody give me a thumbs up in the chat that my audio is still working, just because often when I share screen, somehow it breaks. So somebody test, let me know that you can still hear me. Anybody? There we go. Thank you. And I got some sparkles over here. All right. So we're going to jump into startup formation, equity, and early legal. Everything you need to know to avoid 10 to 15K anymore. It's getting to be about 30K in corporate cleanup when you're starting your startup. And because it is Halloween season, this is the spooky edition of this presentation, which I'm excited to give. So, why on earth do you care about any of this stuff, right? You guys are all startup founders. You're building your product, you're testing your solution, you're doing your go-to-market, everything that is what you should be focusing on is, making sure that there's something real underneath your startup, that you're delivering something that people want, real value. However, you do need to do a little bit of corporate uh, governance just to be sure that if things actually work out, and the failure rate is pretty high in startups, but if things work out, it doesn't all fall apart, which is actually one of the bigger failure cases that most startup. It's not the sexy stories of defrauding investors or raising a ton of money and not working it. It's really just sometimes things fall apart from a corporate governance standpoint. So I like to say 28 months later, 28 days later, whatever you want, but early mistakes generally pile up on you eventually, and they become very expensive to fix. And the problem is usually they become very expensive to fix at the inflection point of things going somewhat well, year two, where it's just like, oh, we finally got this thing working, but all of a sudden, the agreement we had with our co-founder is causing conflict. And now we're talking about the contracts that we signed or didn't sign. And that can really derail a startup success story and eventually overwhelm it. And if you've been in the industry as long as I have, you see so many stories of really cool ideas, really cool companies that just fall apart because of just lack of corporate survival. So there's a bunch of stuff out there. I'm Ryan Nash. I'm the CEO of Gust. I've been at Gust for a decade and a half, almost, it feels like. And we provide tools to help with this, right? So if you sign up for Gust Launch, you get on the rails, you set up your company, everything is click next to continue. It helps, but there's still some stuff outside of that that you can't even solve with software. You just need to solve with kind of a bit of know-how. You got to spend your 90-10 time, spend a little 10% of the time understanding how setting up a company and the structures that are inside a company that allow it to actually do what it needs to do. You know, the corporations we have today are not just, busy work filing. I mean, there is a little bit of busy work and, state departments make money off of this stuff, but it's the result of thousands of years of human collaboration into a shared enterprise and why this stuff actually matters. Why an organization has different bodies of governance, why you do certain things, why you sign certain contracts. It can actually help you have a better chance of building a good startup and building a good company. So throughout this presentation, spooky presentation, we're going to go through some examples of how things can fall off the rails, and they might sound familiar to any or all of you if you've gone through this experience a couple times. So let's walk through some of these, and then we'll get into how you can avoid them or be proactive rather than reactive when they happen. So the first thing is, why do I even need a legal entity at all, right? So this is US based, but it's the similar laws in a lot of countries is if you start doing business, you are already a company. in the eyes of the government that you exist in. So if you just start selling lemonade, out your front lawn, you're what's called a sole proprietorship, or you're, just doing some kind of business, and eventually you will have to, pay taxes on the income that you earn, et cetera. So why would you set up a company? The biggest reason is limiting personal liability. So stuff can go wrong when you do business, right? You enter into a contract with another business that you provide services to. They're a bigger company than you, and you fail to provide those services for whatever reason, beyond your capabilities, or just random stuff happens. And they have a department that will actually just sue you for the failure to provide business. You do not want that lawsuit. It might kill the company, which does happen, um, but you don't want it to kill yourself. You don't want to lose your house. You don't want to lose your car. You don't want to lose the, assets that you've created as a personal individual. So creating a legal entity in the US at least allows you to set aside that liability, or put that liability in another entity. Be like, hey, I'm trying to do a business practice. It might not work out. I'm going to be engaging with a lot of other individuals, whether they're customers or their partners or their providers or their vendors. But I want to be sure that in doing that business, I'm not going to, put myself and my family in harm's way. One of the more interesting things I learned a decade ago when we went over to Ireland for one of the ACA events is that entrepreneurship in Ireland was stifled because for a long time, business debts would pass on to the family. So it really discouraged people from starting new businesses, because unless you were like a sure bet, you didn't want to endanger not just you, but everybody else who depends on you or is just associated with you. Until the laws changed, like entrepreneurship actually started to flourish. And I think we saw the Celtic Tiger and the whole economic blow up of Ireland. I know Stripe is based in Ireland with the Collison brothers. Beyond the scary liability stuff, you need to collect the whatever is valuable into something. It can't just be your good word and your trust. You want to put it into an entity that owns it. So intellectual property, assets, if you're a startup that's building just software, the software, the code, the assets that you're developing is what's valuable. If you're a startup that's doing hard tech stuff, even the warehouses, the distributors, the relationships, everything needs to the value needs to accrete in some kind of vehicle that's other than you. And one of the more interesting things, and something that I've kind of fallen in love with over the last decade, is allowing multiple parties to collaborate around building something cool. And so, learning about the structures of a corporation, shareholders, the board, and the officers, is really an elegant way that humans have figured out how to collaborate around building something together, incentivize the people in the right way, give rewards where rewards are due, etc. It's actually a very useful mechanism to build a company, and to, build it with, durability going into the future. So here's an example. We have ghost stories throughout this because it's spooky season. I also have apple cider here to commemorate the season. But one of these ghost stories is, all right, so you start working on a side project. Here's one. You raise 40K. And when I say raise 40K, it's probably you talk to some people and they're excited about your own passion. Juan has, a friend, an ex-coworker, an uncle who says like, "Hey, I'm doing this cool thing." They're not experienced in this stuff at all, but they're like, "Oh, Juan's going to make a big business. Here's my money." Juan spends the money, builds something, and it doesn't work out. But, somebody who gave him 20K, who has never invested in a startup, is not an angel investor, not a sophisticated investor, maybe not, probably not an accredited investor, is like, "Whoa, wait a second. I gave you 20K. Where is it?" And Juan says, like, it didn't work out. Like, I have to go get a day job. My startup, 90% of startups don't work out. But that person doesn't understand what's going on in terms of startup investing, isn't risk adjusted the way angel investors usually are. And they say, "Hey, Juan, I want my money back and I'm going to sue you." And he sues Juan individually because there was no company to sue. There was no company that took on that, risk or liability. And all of a sudden, Juan is personally responsible for that, lawsuit. And that is not something anybody wants when starting a business. Ooh, what did I miss? Yeah, yeah. You want RIP your company, not RIP you. All right. So when do you actually do this? That was a egregious example, but Most people end up forming a legal entity when they have to. So the number one things that push people over the edge while they're just building stuff and having a good time is when you put a thing in an app store, or you need to get a bank account, you're just going to run up to roadblocks where you need an EIN, which is an employee identification number, which is a lot, makes your entity separate from you, something that's a tax-paying entity separately, or somebody wants to invest in you. And you say, hey, wire the money to my personal bank account. No, no, no. They'll want to wire it to a corporate bank account. So that's usually the forcing function for most people when they need to incorporate an entity. Um, if you're not pushed into that forcing function, which I'll say is often too late, in terms of if you're getting to the point where you can put something in the app store, that means you've developed assets, you've developed intellectual property, you've probably worked with other people. And back to the initial liability case, like you probably should have been putting that into entity rather than yourself. So what we often say is like the best time to incorporate a legal entity is when you can afford to. So, being proactive, if I was just to have a conversation with somebody and think, oh, hey, we're gonna, we maybe start a company together. This could be really cool. If I had all the money in the world, I would immediately incorporate a company and give ourselves ownership based on the discussions that we had in terms of the roles that we're going to play and just make everything ironclad and locked tight. That's not most people's experience. Everything goes a little bit more ad hoc and slowly, but it used to be very expensive to incorporate a company that can, pull in the kind of investors and the kind of, other contributors that you need to make something big. It used to be five to $10,000. So you'd want to like kind of slow game it for a while until you were kind of confident. I will say solutions on the market, some of which we provide, make this much cheaper. It's $450 for us if you want us to incorporate your Delaware C Corp and give you all the documents you need to basically get the founding team up and running. But it might be worth. There's something called the Founders Accord from Charles McCormick, a law firm that's within our network. That is a lightweight legal document that you can sign between you and your co-founders when you're entertaining an idea that might become a company that just lays out some of the expectations of like, hey, when we do this, we'll go incorporate and we'll do things appropriately. And the most important thing of when you should actually form a legal entity is when there's value at risk. If you have customers, if you have other people that you're paying other than yourself and sweat equity, if you're building stuff, if you're acquiring stuff, you have revenue or assets, or you're trying to make a relationship with, a vendor or a partner, something like that. Those are all the cases where you're definitely going to want a legal entity rather than just doing it yourself, shoestring and duct tape style. Let's talk about the various entity types that exist on there. So LLC versus C Corp. What is an LLC? A limited liability company. Right there from the previous ghost story about limiting liability. LLCs are super common. They're 80 or 85% of the businesses that are formed in most states. And all they really do is allow you to protect your liability while you do business and simplify your taxes. So these are fantastic for services-based business like consultants, agencies, brick and mortars, most, plumbers or restaurants or, coffee shops are generally LLCs. And they're pretty cheap. They're, usually hinged upon the person who's doing it, or maybe the one or two people who are doing it. So they don't need a lot of complicated operating agreements or anything like that. There's no fractional ownership, there's no shares, there's no securities. It's really just we're doing a business. There might be multiple people involved. Maybe they take a share of the profits, but all the taxation happens individually. So if you have an LLC or you're part of an LLC, each year when you file your taxes, you will file a Schedule C, I believe it is. And you will just say, hey, here's the income that I got from my business, portion of it or whatever, depending on how the LLC is stacked up. And that just goes into your income tax filings. And that's it. You don't worry. There's no separate entity to be taxed. There's no shares or anything like that. You can get pretty complicated with LLCs, but if you start to feel the itch to get complicated with LLCs, chances are you might want something more sophisticated like a C Corp, which we'll get into in a second. And the biggest thing for probably a lot of people on this call is professional investors just do not invest in LLCs. They do it every once in a while, as long as the idea is the path is to conversion because they already know it. But the biggest reason they don't invest in LLCs is the tax treatment sucks for investors. LLCs have to file K-1s every year to let everybody who is an owner of them know how they can account for their personal income tax. Startups in general, I'm assuming I'm talking to mostly a founder and startup audience, do not have time for that. And also, there's not a lot to, usually they don't make revenue for a while, but they still have to file K1s. They end up doing delays, investors get frustrated. And there's a big downside to that in that if an LLC starts making money, but reinvests the profits into the company to keep growing it, which is what a startup does all the time and is usually the point of a startup, the investors in the company or the owners of the company will recognize income without receiving it. And so that's a big downside to investing in LLCs as traditional businesses. So professional investors generally steer far clear of LLCs. Or if they do invest in LLCs, it's because they're not doing it as an angel investment. They're doing it more of a friends and family kind of thing. Like, I'm going to give you some money because I know you, I understand you. You're gonna make this business and we'll figure it out. But a lot of startups go out there with an LLC fundraising and they hit the brick wall of like, oh no, I would not. There's no ownership. There's no, it's complicated. You're gonna pay a lot of legal fees to get the membership interest right, and there's just tax disadvantages for passive investors to be in LLCs. However, sometimes you're working on a business that you don't necessarily know is going to be angel led, or don't necessarily know it's going to grow as big as you want, but maybe you have the aspirations for that. And I see a lot of founders saying like, hey, like I'll start as an LLC and then I'll convert, if it works out. Um, One asterisk is a lot of angels will just not be interested in that because they want somebody who's building something big from the get. But if you are doing that, check your state for statutory conversion. I think it's about 38 states out of the 50 support statutory conversion, which makes it very easy to convert to a C Corp, foreign C Corp, which is going to be a Delaware C Corp, we'll talk about in a second. Um, but if you're in a state that doesn't, you're just signing yourself up for a lot of legal fees in order, if things go really well, to transition that to an actual corporation. So, what is a C corporation? C comes with tax treatment, boring, subchapter C. It's not just a alliterative kind of thing, but it is the most common type of corporation. It has three bodies of governance: the board of directors, the shareholders, and the officers. And that's very important in terms of how decisions are made, how value is distributed as things go well. And it separates, it's just like a limited liability company. The corporation itself is separately liable from the people that own it, whether they own it as shareholders, whether they participate in it as officers or as directors. And that fractional ownership is very important to investors and early stakeholders and pretty much all contributors. There's a term here, QSBS, that stands for Qualified Small Business Stock. So, one of the biggest incentives at the moment, and has been for quite a while, for investing in startups is something called Qualified Small Business Stock, which is if you own shares of a C corporation and you are the original issuer of those shares. So you could be the founders, you could be an early team member, or you could be an investor. If you hold those shares for 5 years, no funny business goes around. The company doesn't switch entity types or anything like that. If the company exits, an exit is usually an acquisition or an IPO, literally going public on the stock exchange, you are entitled to up to $15 million of tax capital gains, tax-free gains on the appreciation of those shares, or 10x of the basis, which whatever is greater. It is a massive incentive for angel investors because this applies per company. So an angel investor generally has a strategy of investing in dozens, if not hundreds sometimes, of companies over a long time frame, in terms of they know that most companies will fail. 50% of investments just statistically are not going to net out. They're going to lose all their money. 2 to 3, or 20 to 30 might, or 20 to 30% might return, table stakes, whatever the investment was. They might go out of business. They might become a lifestyle company. The investor might get exactly what they put back in. Would have been better to buy a bond. But a small portion of those are going to result in 2 to 3, 4x, 30x of the initial investment if you think about the companies that really go big. And if you can take a 10 million tax-free capital gains on each of those particular companies, that is a massive windfall for angels. It's also a massive windfall for founders. It's a huge incentive to start new companies. So QSBS becomes this kind of important thing. Most startups don't hear about it or realize it in the early days. And when they're talking about entity types and they're thinking, they might talk to a lawyer that's local and they say, oh, well, like tax advantage wise, or like you can take some losses. Every time you go out to lunch with somebody, you can write that off. You'll save yourself, thousands of dollars a year. At the end of the day, QSBS, if you're building a big company, is everything. And that 5-year holding period only counts from C Corp owned shares. So anything you've done with the LLC, even if it was for 3 years, once you convert, the clock starts then. So it's a huge advantage and something that sophisticated angels will actually look out for. Uh, Sutra will get into C Corp versus S Corp in just a second. Um, and the better thing about C Corps is they allow multiple classes of shares. So as you raise funds, you do not, and I think a lot of startups ask this question is like, how many shares should I reserve for investors when I found my C Corp? And the answer is zero, because you don't actually reserve shares for investors. When you start your company, you start it with common shares and you give it to your founders, yourself, maybe some early contributors when things are really early. When you actually raise funds in an equity round, you create a whole new class of shares. So it's like if you started with 10 million shares, which what Gus Launch does and which is pretty standard in the industry, you give them out, give 6 to 8 million out to, the people who are starting your company. We'll get into vesting and various things like that in a second. But when you actually go and raise funds in a real round, you will create a new class of shares called preferred shares that have a bunch of different rights and obligations that are different than the common shares. And that's what investors are interested in purchasing. So you don't need to do the math, the denominator math around, oh, how many should I reserve? You will figure that out later, once things get moving. But a C Corp allows for multiple classes of shares. And if you look at, a 10-year-old startup that's still private, you might see they have Series D shares, Series F shares. They've created so many classes of shares to both diversify the ownership, pull the money in, and put protections around each shareholder class. Oh, more growth stories is fun. So can I just switch? I talked about this a little bit about statutory conversion, and you can. But if you're really gunning for a high growth company, there's really not a lot of evidence to say that you should play cute games with, LLCs to C corps, try to like eke on a little bit of tax treatment or whatnot. It's almost always just C corp and let's go. Here's an example. So Juliana starts a local LLC. Chances are she probably works with a lawyer, sets up some custom operating agreements. Things feel really good. She's got, a whole operating agreement that says, oh, she owns 80% of the business. Her co-founder owns 20%. They'll share any profits pro rata distributed, this and that. They have voting rights. She's got super voting rights, whatever it is. Spends probably a couple grand just to set that up and gets to work, hires a dev shop. That co-founder has some vague amount of ownership that is in the operating agreement. People invest in her, investors that might not be sophisticated angels, but they might be people with money who say, hey, you're building a cool business, so here's some money. But then they see, oh, you're an LLC. Oh, I don't invest in LLCs. So you need to convert to a C Corp. Just the friction of that alone could set the company back a month or two from receiving the cash. Conversion is not a simple thing. We can actually do conversions. Gus Launch, we are beta trying it out. So if anybody is sitting with an LLC that's becoming a high growth company, nash@gus.com is my email. We're doing kind of a limited trial to help people convert if they're in qualifying states. But the general cost up until what we're doing is thousands of dollars, tens of thousands of dollars in some cases. A lot of lawyers quote like a flat 10 grand to do a conversion because they know there's just a lot of things out there that they need to account for. And they pad the billing. So already you've spent 10 grand just to do the conversion process and the conversations and then you have to talk to your accountant and everything. So you raise, a small amount of money, a pre-seed round, like 150K, but then you spend 30 of it just to get yourself in the position to take it. It's usually not worth it. So if you're going to build something big, if you're going after, a tech-enabled company, a company that's going to raise funds from angels, a company that's going to give shares to their employees to incentivize them, or a company that has a goal of going public someday, it's almost always cheaper, better, and less of a hassle to just start as a Delaware C Corp or C Corp in general, but Delaware we'll get into in a second. All right, let's talk about international existing entity options. So Delaware, I've been saying the word Delaware a lot. I do not live in Delaware. I'm in New Jersey, right outside of New York. Why Delaware? Delaware has the largest body of case law, and is very corporate friendly and has very corporate friendly courts. And it's the overwhelming majority of investors prefer Delaware C corporations because they know exactly how they trust. They don't even know. They don't need to know. They trust that things will be handled, as intended. So if you own 5% of a company that goes public, you will get 5% of the distributions based on this huge body of case law. And it sounds silly, but you will see it over and over in the industry. It's like every once in a while, a strange, bizarro company gets incorporated in a weird state because of a weird law, and the founder has multiple exits, and it makes total sense. You've probably heard it in the news with Elon Musk arguing about Texas versus Delaware because he didn't like what the Delaware courts said about his billion-dollar pay package. But unless you're Elon Musk or the richest person in the world, or you've had five exits behind you, you just want to go with Delaware. It is the gold standard, what everybody expects, and they'll force you to convert to it anyway. Even if you start something else, then that's going to be a cost on you. If you are an international founder or you already have an entity, Delaware doesn't care. They will incorporate you. They're happy to be your domicile of business and collect their franchise taxes every year, even though they're pretty small. But yeah, anywhere you're at, if you're going after the U.S. market and U.S. investors, chances are you're going to want a Delaware C corporation. If you're starting a new one, just pay attention. You'll need a US based address. You can't do it with an international address. And if you're an international founder, you might have some delays with setting up a bank account, but it's totally possible. Hit us up. We do it all the time. We set up international founders with Delaware C Corps and get them bank accounts. If you're already set up, say you incorporate with like InkFile or LegalZoom or something like that, you have a couple options in terms of setting up your company. The easiest one and the cheapest one is often just like if you haven't done much and you're realizing this for the first time, just dissolve it and start it again in the new state. Uh, there are some other options. Statutory conversion, I mentioned with the LLC, is the easiest one. If you're an LLC or you're a C Corp in another state, most 38 states support statutory conversion. It's a simplified filing process. Basically, the business continuity is maintained. So if you built an app, you got some customers, you signed some contracts, and you don't want to redo all that, you can do statutory conversion. It'll cost you, if you work with us, a couple grand, 2 grand is our onboarding fee for LLC statutory conversions. And then you jump on the Gus launch and everything's cool. If your state doesn't support it, there's statutory merger. This is lawyer territory. You're going to just have to work with custom counsel, which means it's going to be more expensive. But if you've got something of value in the outside state, it's usually worth it. And you should have the resources to do a statutory merger. Non-statutory conversions are super lawyer time, um, and usually something that I would definitely say just look at dissolution, or you should have enough resources to basically pay the big guns to figure out what you need to do. What approach depends on your situation, but eventually investors are going to want to see the Delaware C Corporation gives them the confidence to do the investment. Suchitra, I hope that I said that right. What about S Corps, B Corps, all these kind of things? So an S Corp is not an entity. An S Corp is a tax election that you can take on top of a C Corp. You can also do it on an LLC. Um, what it is, it allows a company to be taxed like a pass-through entity, like an LLC. But it puts a bunch of requirements around it. So you can't have more than 100 shareholders. All your shareholders have to be US based. And most importantly, you cannot have other business entities being a shareholder of your company. If you get into angel territory and professional investor territory, you're going to find out a lot of angel investors invest through an LLC, not your LLC, but they set up an LLC to handle their investment accounts for tax purposes and simplification. And they want that LLC to be on the cap table, not themselves personally. So that's why S Corp is a big kind of like friction point where it seems really appealing because like, hey, maybe the first 2 years of the company when things are tight, you're making like money, maybe doing some consulting through the company while also trying to build your product. Hey, you can take some of those tax losses through a pass-through entity. The reality of it is it usually just messes up, all of the the desirability of investing. Good news is if you do an S corp for a year and then you don't, no issue for investors. However, there's one small wrinkle. And this is like where law gets into it's only what's ever been litigated in case law rather than, what's written out clearly. That QSBS status that I talked about 10 minutes ago, qualified small business stock, does not apply to S corps as far as anybody knows. So QSBS has very little case law about S corps, but QSBS demands that the company has to be a C corp for substantially all of the 5-year holding period. And nobody has ever litigated what substantially all means. Some people say it's 80%, some people say it's 50%, some people say it's 100%. But if you're building a big company and you want to protect that QSBS status, both for you as a founder as well as the investor that you're going to bring on, an S corp election is almost just like don't throw the question into it. And often the tax savings just aren't worth it. Usually in the early days of startups, the amount that you're spending and the tax breaks that you can take from it, for like booking a business dinner or something like that, just isn't worth, foregoing or even just complicating the upside that QSBS provides. B Corps. B Corps were increasingly popular. It's gotten a little quiet, but a B Corp is just basically a C Corp with a public benefit on their COI. So a lot of people took umbrage with I don't know if you've heard the old 80s thing of like shareholder value is the primary reason for starting a company and like everything needs to be prioritized by shareholder value. And you'll see lawsuits all over the SEC, shareholders saying companies are not protecting their shareholders. A B Corp allows you to have one additional governance. I wouldn't even call it a structure, but just a governance statement that allows the company to make decisions based on not just on shareholder value, but also a public benefit. And they have an obligation to, maintain and report on that public benefit annually. Usually that doesn't really come into place until you're a public company because nobody's checking your private company's filings or anything like that. I would say at the moment, um, a lot of founders get really excited about B Corps because they feel like it is some kind of differentiation. But in reality, like if you're trying to make a real business succeed, just start with a C Corp and try to make waves. Once you actually establish yourself, you can adopt the public benefit designation. You can change your corporate charter to adhere by the benefit. It doesn't really provide any additional governance structures that are useful, and it is mostly a marketing tactic at the moment. We don't have a consortium or enough history of humans being able to litigate what the public benefit is or if a company is fulfilling it. And the B Corp designation, or sorry, the B Corp structure, like I said, is just like a C Corp. But you do not automatically get a B Corp certification just by incorporating a B Corp. You have to go through the B Corp uh, company or organization and consortium to actually get approved as a B Corp so that you can go and stick that on your website. And state by state, the entity type is actually less important than the qualifications that you have to go through that certification. So they might force you to turn into a B Corp if you're in Delaware, but it's really not worth a ton of time and attention for founders who are just trying to get, 0 to 1 style stuff. But I do think a lot of people get fixated on it. All right, so how do you actually set up a Delaware C corporation? Pretty simple. You file a literal document with the state of Delaware, they stamp it, and they turn it back to you. We do that as a service. For a startup, the most common things on that certificate is about 8 articles. Most of them are just boilerplate, like you're going to do lawful business. Here's your address. You protect the liability of the officers and the board and whatnot. But some of the important things in there are how many shares your company has and what the par value is. So by and large, gold standard for C Corps for startups is 10 million authorized shares with a very low par value. We do 4 zeros and a 1, 0.00001 dollars per share. The reason is twofold. One, you need a lot of shares to incentivize people for very low percentages, but long vesting schedules. So if you're going to bring an advisor onto your company, you're going to give them 1/10%, 1/4% of your company, but you're going to want it to vest over 2 to 4 years. And if you only have 1,000 shares, it becomes really difficult if you think of, a fraction of a percent of 1,000 and then vesting it over 4 years. Is it every 7 months or whatnot? It doesn't make sense. So those millions of shares are useful to incentivize people of all kinds of roles. You're going to give yourself millions of shares because you're the founder, and your co-founders are going to get millions of shares, but you're going to have a lot of team members who get very small share grants, and you want to be sure they have meaningful vesting schedules. So once you file that piece of paper, it says, hey, here's a company, 10 million shares, point one ten millionth of a dollar each. It gets back from the state of Delaware. What do you do with it? You're not a company yet. So you have a filing in Delaware, but you need to set up those three bodies of governance that I talked about. So the first thing is usually appointing bylaws. So bylaws are the rules of, how the company runs. Most of them just refer to Delaware corporate law, but in modern companies like the ones we set up, there's just a lot of conveniences of like, hey, we don't have to have in-person meetings. We don't have to take secretary notes. We can do things, with consent in lieu of meeting if everybody agrees on it. We can do digital records. We can do digital finances. We can do, our end of the fiscal year is December 31st. Just make your company make sense in the modern world. So once you have the bylaws, then you appoint the board of directors. So the board of directors is the buck stops here part of the company. So the board they appoint the officers and they make most of the decisions in the first 3 to 5 years of the company. So almost every stock grant needs board approval. Assigning officers needs board approval. Raising funds needs board approval. And usually for a startup team, like the co-founders are on the board. Later on, when they raise funds, you might see one investor on the board. Kind of a 2 to 1. You always usually want an odd number of members on the board to make sure that you can't get a deadlock in terms of voting. But they're really the controllers of the company for the first several years. And then in order to establish the entire corporate veil, you need to have shareholders. So board, officers, and shareholders, those are the bodies that you need appointed, within the first month or two of setting up a company. Officers are kind of superfluous in the modern day, but they need to be appointed. So the three officers that Delaware cares about are the president, CEO, which is usually a conjoined role, the secretary, and the treasurer. Secretaries and treasurers don't do much these days because mostly software like our own and QuickBooks software and things like that kind of automate their jobs. The secretary used to literally stay there and record the meeting minutes, as the board was meeting and making decisions. That just generally happens through software and documents now. So the secretary's role is kind of superfluous. Treasurer is supposed to be responsible for all finances. Often you'll appoint a co-founder to be the treasurer, the person who is most familiar with QuickBooks or has access to the bank account, but they usually don't have day-to-day roles as that position. But the president and CEO is generally the founder of the company, the CEO, the end decision maker, as the most important officer. Officers do have the ability to basically do all the other corporate actions. So once you adopt the bylaws and you appoint the officers, it's usually the board who's going to approve a thing and then the officers who are going to execute it. So often, like if the board approves a stock grant, they will charge the officers with actually facilitating it, getting the necessary signatures from the grantee, the CEO itself, etc. If you adopt an option plan, the CEO is going to be the one who initiates, signs, and adopts that option plan, even though the board will approve it in advance. So getting all that stuff together used to be non-trivial. You would pay a lawyer 5 to 10 grand to put all these documents in place, tell you where to sign on the dotted line, etc. It has been made much easier in the modern era. Gus Launch will do this all for you. Clicks next to continue kind of style. You can get yourself set up. You can grant, you can appoint your officers, appoint your board, and grant shares with, several just clicks of a workflow. The last thing you want to do once you get that all set up and you get those bodies of governance in place, and the important thing about getting those bodies of governance in place is the corporate veil is not established unless you have all three bodies. So if you just file a piece of paperwork with Delaware and say, oh, I have a corporation now, and you start doing business under the name of that corporation, and then later something comes up, a lawsuit or, usually always a lawsuit or some kind of contestation, if you don't have those three bodies, it's what's called a shell corporation, and you could end up becoming personally liable for whatever lawsuit happens. So just filing the piece of paperwork is not enough. You want to set up the full entity, so that if anything weird and crazy happens, the corporate veil is fully established, and even if they sue your company on into oblivion, they don't take your house. The last thing is once you get it all set up, chances are most of you don't live in Delaware. So actually throw your locations in the chat if you want to. I'd be very curious as to where everybody's coming from. But because you're running a Delaware corporation doesn't mean you have to live in Delaware. you can just foreign qualify in the state that you are living in. So if you're a US based company, so foreign qualification is usually it's like $9 in New York or like $200 and like a $9 a month fee. Some states are a bit onerous. California is specifically notorious. They have, I think it's a $400 filing and then like an $800 a year, franchise tax that they put on your company. This is stuff you can do in a couple months after you form your company. Hey, New Jersey, I'm with you. New Jersey is actually fairly nice. The fees aren't that much, and the annual reporting requirements aren't too onerous. But you'll eventually want to do that. Don't make it your primary point of business, but you'll have to do it eventually, or the state will catch up to you. You'll have to do it eventually. Do I really have to do all this? Here's another example of why you want to do some of this. So say, somebody who's, listened to this webinar is mildly aware of it. They start out with Delaware C Corp, points himself as a director, but doesn't issue any shares. This is a super common situation where founders get kind of like, I don't know, nervous about signing documents amongst their co-founders. And they talk about ownership. They say, oh, it's going to be 60/40 or it's going to be 30/20, can't do the math. Yeah, 30/20/50. And they just don't do anything, but it's an understanding amongst the founding team. This happens a lot because signing documents, talking to lawyers, codifying things is not top of mind when you're trying to build an app or, build a product or anything like that. So they don't issue shares. And they don't foreign qualify because most people don't know that they ever need to. But things go well. Generally, startups are built on momentum and building something somebody wants. So this company starts making revenue. And by the end of the year, the first year, probably the second year, they finally get to their books and taxes. One of the biggest things to take away from this is like nobody's going to knock on your door 3 months after you incorporate to tell you what you've done wrong. It usually takes 2 to 3 years before somebody catches up to it, but then the mistakes can pile up. So you could literally file a Delaware C corporation, take money, get a Stripe account, start to make revenue, get customers, do all this stuff. And nobody's going to come around and say, hey, you didn't, foreign qualify. Oh, you didn't actually pay your franchise taxes. Oh, hey, your company is voided in the state that you incorporated in because you haven't done the things that you're supposed to do. It's usually not till like many years later that you'll actually get these notifications. But a lot of times when it comes time to clean this stuff up, it becomes so burdensome on such an early company who might have revenue, which is a miracle, but just not revenue enough to handle this kind of thing. I have a personal experience with a company that raised a bunch of money, had huge press, was going out there. I think they got up to their Series A, but they didn't realize the taxes that they should have been paying both on payroll and for their entity. And when the tax bill came due finally through like a service of process or something like that, they had just finished like a seed bridge round, and the tax bill was so big that they went back, they didn't have enough money in the bank to cover it. And they went back to their investors and said, whoops, like, could you give us some more money? And they said no. And that company folded. So these things are real. And keeping just a little bit of 80/20 ahead of it can help you, not be exhausted like this poor character. And in this particular case, the example of because there was no shareholders, because there was no officers necessarily, if things go really bad, it could literally go back onto you personally. Oh, God, I'm verbose. Okay, so we talked about these 10 million shares. How do you actually manage the distribution of that fractional ownership in the company? So the most important thing to do is to get on the same page with your co-founders before you do anything with paperwork. Often corporate governance paperwork, I think, is the memorialization and the canonization of discussions that happen in the real world. So the most important thing is to have a discussion about who's bringing what to the company and what level of ownership that maintains. Bringing what could be skills, assets, IP. Some people might be funding the company month over month, just, a little bit, a couple thousand here and there, just putting in the corporate bank account so you can pay your AWS bills, your Gmail bills, your et cetera bills. Other people might be working part-time, but just figuring out what that split is. We do have a tool that really helps with that, which I'm going to put in the chat right now. That's a tool, a free tool that will walk you through the conversation, and you can do it with your co-founders. You can send it to them after you do it to see like, what is the actual ownership split based on the contributions. Biggest thing, like I said with the previous example, promising equity is not the same as issuing it. And there's a ton of reasons why you should issue it and not be scared of issuing it because vesting schedules allow you to protect the company if things don't work out the way you want it to. You don't want to just hold on to this idea of like, yeah, I'll eventually grant you shares, once things work out. Have the conversation, issue the equity. The biggest thing is it starts the QSBS window, which is 5 years. So that's a long window that you want to start as soon as possible. And it also provides the voting rights and the governance structures for the company, both establishing the corporate veil and, talking about how this company is actually going to be run and who has a say and how significant that say is. That 10 million shares that you authorize, you do not issue all the 10 million. So it's the denominator. That 10 million is really just a high watermark that you put in on file with Delaware that says I can't issue more than this. There are many startups who issue 6,833,124 shares of common and never issue anymore. That's fine. The ownership is only ever based on how much is issued. So don't get too worried about the 10 million. 5 million shares is not 50% of the company. If you issue yourself one share out of that 10 million, you own 100% of the company. If you issue your co-founder one share, now you both own 50% of the company. That is how ownership goes. The only complicating factor is when you do an option pool, you'll reserve a certain amount of shares that you might not all issue. And most investors and people will consider whatever is reserved as issued, even though it hasn't been issued yet. So if you reserve 10 mil or if you reserve a million out of your 10, that is 10%, or you would think that would be 10%. It's not, but that is, represents, kind of a share class or a share reservation. And that is why you generally want the founding team to issue between 6 and 8 million of those 10 million shares. Why between 6 and 8 million? One, taxes get weird if you issue under 50%, just not horribly weird, but if you have a bit of assets, you might end up paying, one, two, three, $4,000 in franchise taxes to Delaware rather than $400, which is the minimum that most startups pay for the first 5 to 7 years of their existence. And it's just, like I talked about before, if you bring on advisors, you're bringing on small share grants, you're going to be issuing them, much smaller amounts while you'll be sitting on millions. Like I said, you don't have to reserve stock for investors. Common stock generally goes to the founding team, early contributors, and advisors. You don't have to really worry about, saving anything for that, and everybody gets diluted altogether. So don't think about super voting shares. Don't think about non-dilutive things. If you grant yourself money, if you grant yourself shares and you say, "Oh, I want these to never be diluted," that is a massive red flag. You don't want to complicate common equity structures. You want very simple share agreements. Chances are the founding team is going to own the vast majority of the company for the first 5 to 7 years of its life. And every time you're going to change that equation, you're going to do it with counsel and backup and negotiation. It's not going to be like a trick of the switch or a trick of the contract. You just want to keep things pretty simple. Somebody's asking about 83B. Before I get to 83B, let's talk about vesting because vesting is what triggers 83B. So what I said is you don't want to promise this equity and not grant it. Founders get scared that if they grant ownership of their company to one of their co-founders and things don't work out, say they're working part-time, they say they're going to quit their job as soon as X happens, like what's going to happen with that? I gave them 10% of my company, etc. Vesting is what protects you in that. So every common stock grant should have a vesting schedule. And what vesting is when it comes to common stock, it's actually what's called reverse vesting. So the ownership is immediately assumed. So if I grant my co-founder 10% of my company, they have 10% voting rights. Now they can't really use that to, overturn anything in the company, but they're legitimately a shareholder in that company, starts the QSBS clock, everything's cool. But I put vesting on that stock grant that says, hey, this grant is going to vest over 4 years and there's a 12-month cliff. So what that means is while you have 10% voting rights, if for ever any reason you leave the company within that 4 years, whether voluntarily or dismissed, whatever is not vested will immediately get repurchased by the company or has the right to be repurchased by the company at the same cost that I granted it to you. So that 10 millionth of a dollar. Why this protects the company and why we do a cliff is most jobs it takes a year to figure out if you're actually doing it well and if you're a good fit for it. And that protects the company. You bring on a co-founder. They say they're gonna, they're part-time, they're gonna go full-time within 6 months, they're gonna quit their job, they're gonna do everything great. You give them 10% of your company. And then, 3 months later, they're like, I can't. I just got promoted. The salary is great. Also, like my partner, wants to buy a vacation home. I don't know. and they're out. You don't want 10% of your company into that individual who's no longer contributing to the company. So in that case, if it was only 3 months after the engagement, you can say, oh, fine, you're no longer a founder of this company. You're terminated. Violent word, but it is the word. And the company can buy back the entirety of that grant, for the 10 millionth, if it was a million shares, it would be for $10. Vesting is the way you protect companies' ownership to be sure that the ownership reflects the contributions over time. Advisors are a great example. They get, 2 to 3 year vesting schedules with like a 3 month cliff. Advisors should be super high impact, super fast. They should be way connected, way experienced. And if they're not, something like, I'm an advisor company, here's the advisor agreement. Give me my half of a percent of ownership, and you're like, you canceled the meeting twice in a row. I haven't talked to you. It allows you to pull that ownership back and not have what's called dead equity on the cap table. So vesting, super important provision to protect the ownership of your company. It comes with a complication that people are asking about in the chat. So when you have a stock grant with vesting, the way the IRS perceives that stock grant is that it is not irrevocably yours until the vesting has happened. So even though you have 10% of the company ownership voting rights, the IRS says, no, you don't. Like, the company can pull that back if you leave. Therefore, income-wise, by default, the IRS is going to assume an income event for every time those shares vest, and most shares vest monthly after the cliff. What that means is if you're building a high growth startup and you're 2 years into it and you're halfway vested and the company is no longer worth $100, but now it's worth $10 million, and you have millions of shares in that company, every month you're going to be vesting hundreds of thousands of shares, and those are going to be at the value of whatever the company has grown to be. And the IRS by default says, oh, look at you, you're vesting, 400,000 shares a month, and the company's last valuation was blank. Therefore, you have income of that. You do not want that. You start a company that is super cheap and worth nothing from the beginning because you're going to grow it really, really big, and eventually you're going to sell it, or you're just going to run it in perpetuity and pay dividends and, draw a great salary or whatever you want to do. So there's something called an 83B election, which you should do within 30 days of any stock grant, and you should advise anybody who you grant common stock to. So what an 83B election does is it tells the IRS up front, hey, I'm going to forego the right to take losses on these shares. So I'm going to pay for all of the income tax up front in this calendar year that it has been granted. And because I'm paying cash for it, that is zero, and that is a zero income event for you. There is very few cases where you do not want to file an A3B election if you're a startup trying to build in a high growth business, because it will allow you to avoid significant capital gains or income taxes in the future. Uh, if you've messed this up already, which I know some founders might be a little nervous sitting in here if they missed their 83B election because the window is 30 days, and the IRS is very strict about that because they're trying to prevent tax fraud. Enron did a ton of tax fraud before the 83B election was created by issuing options and messing with the dates and things like that. Um, if you missed it, get some counsel. There are some ways around it. You can do an accelerated vesting schedule, or you can do what's an old and cold approach where you basically fully vest it and then put vesting on later because investors are going to insist on it. Don't get too scared. It is going to cost you some money, but it's worth rectifying um, before it's too late. Another ghost story. Jesus, I'm almost catching on time. All right. So here's an example of all the stuff we stacked up right now. So we're doing things right. We set up a Delaware C Corp, but they only authorize a tiny amount of shares because they talked to some lawyer who said, oh, if you have less than 1,500 shares, like you only pay $180 in franchise tax, or if you have more than that, you'll pay 400. That's fine. But they put a weird value on it, a tenth of a dollar. They grant some shares to themselves, to their co-founder. There's no vesting on it. The co-founder leaves. And this is to one of the questions in the chat. Um, they don't know what they're doing, so they buy back the shares. I'm not realizing that when you buy back shares, if you remember what I said 30 minutes ago, QSBS only affects if you're the original shareholder. So if you repurchase shares rather than through a vesting agreement, which is a repurchase due to termination, if you buy back shares for market dollar value, not only do you price those shares in some way, even if the price hasn't changed, but it invalidates those shares to have QSBS treatment. So if you then redistribute them to somebody else, or honestly, in this case, this is a sad case, it pretty much blows the QSBS status for the entire share class because there's some complicated laws around there. So they lose the QSBS status. And then they find out, hey, we want to issue a small grant, but we only have a couple hundred shares. We can't do it. So then they go file an amendment. Now they have a bunch more shares. But because they bought back shares, they put a price on the shares. So even giving stock to somebody for a small amount forces them to pay a good amount of money or to take an income tax hit for that, which complicates a relationship, which usually means they go and amend it again. And then you just get into a mess where you're paying lawyers thousands of dollars to fuss around with paperwork and also mess up your incentivization structure. And so that can really put the company in almost like an untenable situation. I'm going to go a little bit over because I'm verbose. So what even gives shares in a company any kind of value? Money in the bank, most obvious one. If you raise a certain amount of funds, you're going to pump up the fair market value of your company. IP is valuable if it's producing value. Some founders get really hung up on the idea of like, I got a patent, I did a thing, I have an MVP in market. That IP is not valuable unless market tested, where somebody in the market has said, yes, this is valuable, usually through revenue, possibly through LOIs, possibly through usage. There are some startups and companies who have a pure IP approach where they acquire patents and on methods and procedures, and then they license them out to other people. Those startups are fairly rare and usually started by people who already have experience in the space. But don't get too obsessed with, patents and IP in the early stages. It's really about producing market value, that it's going to give your company some value. The people in your company is valuable. I don't know if you've seen the recent news report about the company that hired 10 of the top AI researchers and LLMs and raised funds on a pitch deck that said, we're not going to tell you what we're doing. But they ended up raising billions of dollars. It happens. It's rare. It's usually not the best approach for probably anybody in this call. But the people on your team can provide, a significant amount of value in investors' eyes. Fortunately, that doesn't reflect in the stock price until you actually start doing some business transactions. Common stuff, assets, warehouses, equipment, machines, if you're a physical product company, if you have inventory and things like that. And then obviously customers, contracts, and orders, revenue, a contact list, frequently paying people, a distribution network. That is what will put value into the company, and that's what you want to focus on building. So you want to protect that, what we talked about, establishing the corporate veil, a full governance structure, board, shareholders, officers, separating that self from you personally and your founders, making sure that everything is assigned to the company. I think a lot of startups get started by people who are really excited about a different thing and have worked together and they just start building, which is exciting, but you want to be sure that whatever is built is owned by something other than the individual. So if you're an American citizen and you're not under an employment agreement with another entity, anything you create is yours by default. A creative work, absent those kind of agreements, you own. So when you're starting a company, you want to be sure that if somebody is creating creative works for the purposes of the company, they actually get into the company, and that's done through what's called an IP assignment. It's a pretty lightweight document. It usually through Gus Launch, you can basically you can set aside stuff that is maybe your own. So say you have your own personal blog or you do your own, you have an agency or an LLC that, you're doing some consulting with, you can, exclude that from it, but you want to be sure that everybody on the founding team signs an IP assignment. This is often overlooked for founding team members because most other contracts handle IP assignment. So if you do a contractor agreement with a contractor or an NDA with, somebody that you're talking with to do a partnership or even an advisor agreement, the IP is covered in those agreements, in a subsection. But founders often don't sign an agreement, and they're usually not, W-2 employees, so they're not signing an employee agreement. So be sure you have an IP assignment agreement to clarify the ownership is very important. Like I just said, contractors, advisors, other people, all the IP is generally handled through those agreements, and those are pretty rote standard boilerplate agreements that you can have. Be sure everything is board approved. A lot of founders sign something like, our friends over at Founder Institute have this great advisor agreement called a FAST that has a worksheet with like how much equity the advisor should get between 0 and 1%. And it's great. And there's a little line in there that says, hey, there's going to be a stock grant for this, and this is how much you're going to get. But the line has an asterisk that says the grant will be deferred to the grant documentation. So they'll sign this 3-page agreement being like, oh, I just granted you, 0.5% of my company. And in reality, they never actually did the grant because the grant usually comes with a lot more paperwork. So be sure that you're fully doing all this. And you know, building your cap table and maintaining it is very important. So you know who owns what percent of your company, and so making sure you get these grants in order is definitely behooves all of you. So 2 minutes over seems like a lot. It is a lot to set up and run this kind of stuff. That's exactly why we built the company that we built and the product that we built. So we basically have a click next to continue, full corporate governance solution called Gus Launch. We literally incorporate you in Delaware. We provide all the agreements that I talked about, all the way up to option plans, safes and convertible notes, simple things like NDAs, complex things like, stock option plans and option pools. And it's super easy and people love it. It's a lot better than cobbling together something like Carta and your lawyer's conversation and some spreadsheets and some templates and PDFs, and make sure that you have a complete corporate history, fully backed up by all the documents that you signed. And it's pretty great. And we've got thousands, maybe even tens of thousands of companies on that by now. And it's a really good way to manage your startup. All sorts of fun stuff. Look at that. And you can manage your whole cap table and get a good view of that. If everything I've said here is, a purple haze of new terminology, things that you're not entirely sure, like, am I starting a startup that actually has to do what the hell Ryan's talking about, or am I just starting a business, or I really need to dig deeper on this? We have a new program that doesn't require you to incorporate your company, doesn't take any equity, isn't expensive at all. It's called Mission Control. And think of it as basically like this presentation, but as a dialogue every day. Not every day, every week through office hours. We do pitch practice sessions. We have one later today, actually. We do financial model teardowns and reviews. And the heartbeat of the whole program is office hours, where you get to talk to me, you get to talk to Pete, our CEO, a handful of experts in our network to just demystify and translate this insane industry, which sometimes seems counterintuitive and a little esoteric, but makes a ton of sense, once you really dig into it. And it's one of our favorite programs we run. I guess it's in its second year now. We've had some really cool success stories out of it. Founders who've jumped in, wide-eyed and naive about what kind of company they're building, and then figured out, oh, this is how I need to communicate my company. This is how much ownership I should give my co-founder and myself. So it's a really good level up for anyone in the space. So I encourage you to check that out. It's 99 bucks a month. Cancel anytime. We'll refund you if you don't love it, because most people love it. But it's a really good way to just kind of speed run your startup journey. So I'm going to take a little time to glance through the chat. I'm sorry, I'm solo today. Normally I have an assistant, but I will try to get any of the questions in the chat, and then we will wrap. All the way back to Mohammed, our Delaware company is only applicable for startups targeting the US market. Slightly nuanced answer there. So, targeting the US market, probably targeting US investors, definitely. So, other countries have, active angel and VC ecosystems. I think the UK and France are the second two largest after the US. China and India do have them. They're not reported on as uh, accurately, at least in terms of the U.S. market, but it is there. There is, if you're going to go after U.S. investors, definitely Delaware. If you're going to go at the U.S. market, you might be able to get Canada, sorry, is also in the top five. You might be able to get by with a foreign company for a while because, borders are porous depending on your, services, right? If you're a physical product company, probably difficult unless you get boots on the ground somewhere in the US. But if you're a software company, right? Spotify, Ireland, or not Spotify. Spotify is not French, Scandinavian, no, Switzerland, uh, Sweden. So there is definitely a means to get customers outside of there. Often, though, if you're going to raise funds, U.S. investors are generally pretty set on Delaware C corporations. There was a period of time, 2021, um, cash was flowing like crazy. People were investing in some really wild things, and people got a little loose, and they were investing in foreign companies and things like that without full confidence of how, their investment would be tracked and whatnot. That has died down a bit. since, macroeconomic changes, interest rates, and things like that. So the angel and VC ecosystem is largely in the US, still focused on Delaware companies. You might get a little purchase with a UK or Canadian company if the narrative makes sense or the momentum is so big that an investor is willing to kind of like let down a bit of their litigation guard to jump into something foreign. Da-da-da-da. Andrew, I think I talked about limits on outside investors for both LLCs. Andrew does bring up that a K1 is one page. Absolutely. Getting companies to file it appropriately, even though it's one page, has been notoriously difficult and terrible. Investors have been spooked by it for years because it constantly makes them have to defer. I literally invested in Death and Company, who was an LLC, which, XX, but I did it because my partner works in that industry and they missed their K1 filing date, obviously, because you have to get your accountants, you have to get everybody. It's not about the page itself, it's just about how much work that you have to do in order to get the information that needs to be in the K1 out there. And a lot of small companies just don't have the time to do that calendar appropriately. So it is often a huge hassle for investors. You will often find angel investors increasingly invest in companies through something called an SPV, which is an LLC, but it's a special purpose vehicle in time and designed to have an entry on the cap table of that company so that multiple investors can pool into that and the company doesn't have to manage, a dozen or 2 dozen different investors. SPVs also have to produce K1s, but most people that create SPVs, like Sidecar, it used to be Assured, they went out of business. There's a half a dozen other ones. AngelList does them. They call them roll-up vehicles. But they are systematized to actually produce those K1s at a more regular cadence. Yeah, and Stan, thank you very much. Just kind of backing up the things. LPs at institutional VC funds legally specify they cannot be given ordinary income on their K1s, so no LLCs. That is also something that goes into an SPV's paperwork. So SPVs are very specifically structured to basically abdicate almost all decision-making responsibility from anybody in it, as well as structure the tax structure so that the investors don't have income events other than at an exit. Do 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 do. Mohammed, I think I kind of answered your question about the MENA region, if incorporating in Delaware makes sense or not. It's really about where you're going to get investment from, whether you need to do that. I think we talked about the pros and cons of C Corp versus S Corp. Profits and interest units, Jeff. Yes, you can set up an LLC to do all sorts of membership units and distributions and things like that. If your business is meant to be owned by just a handful of people, not meant to, have fractionalized ownership, vesting schedules, security classes, QSBS, you can design it into it. You're going to have to talk to a lawyer, get yourself an operating agreement that makes sense. But usually for a high growth startup, it's not worth the time because you're going to end up pushed into a C Corp structure anyway. Alda, we can definitely move a New Jersey-based C Corp to Delaware. We've actually done one in the last month. Reach out to me. I'm nash@gus.com. I'll hook you up with Robert from our team who actually does the conversion and onboarding process. We're increasingly systematize that. Everybody, I hope in a year from now, I can literally give you a link that's just like convert your entity right here, and we'll do it completely through software. We're doing it a little bit white glove right now because it's complicated. Da, 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 da. Oh yeah, Stan. Also, Stan. Standing in the stand. Yeah, corporate, not federal taxes come back to you as an individual who screwed up. Yes. One thing to look out for if you're in California, this doesn't often happen because founding teams are, um, founders. So they're usually, kind of like married at the hip, or, it should be kind of a marriage. But there are certain states, California, the most notable one, that if you're working for any company, you are technically, you should get minimum wage. Founders usually don't collect a paycheck for the first X amount of time until they either get enough revenue, raise enough funds, and they're usually putting that money back in the business, so they collect very little. California specifically, if you had a co-founder who you weren't paying and it ended badly, they could come back to you and say, you owe me back wages, because California law says that I should have been being paid at least minimum wage for all the work I was doing. It's usually not an issue because it takes the individual to act on it, but it's something to be aware of if you're in a state like California. Da da da. We talked about 83Bs. Doesn't apply to LLCs at all. Um, so don't worry about that. Thoughts on buyback and co-sale agreements. I think I covered a little bit about buybacks. You don't want to do them. You only want to do buybacks based on vesting schedules. There is something that you can kind of do with legal help, where often if somebody is departing a company and you exercise the repurchase agreement based on the vesting, but you want to give them cash because things are going well, you can often do an agreement that's basically like the this happens more often with options rather than common stock. And you can do whatever you want with your company, right? You can give somebody a bonus. If you want to use the stock that they owned and sort of vested as part of the calculation, but usually you just don't want to touch the security valuation in that. So if somebody's been with you for three years, they leave, the company automatically buys back, the quarter of the shares that they had that, hadn't vested yet for the par value that they were issued at. Let that transaction be its transaction. But if you want to talk to that employee and be like, hey, you were amazing, we're just going to give you 50 grand, and we looked at how many options you had left or whatnot. You can do that. Just don't try to tie it to the security price and things like that. Yeah, Stan. Also, yes, Black-Scholes Merton model. Oh God, the Enron, little things that ripple through our industry. There is something not to get confused of for all founders out there. Valuation of your company in terms of the pre-money valuation in which you raise funds at is what you convince investors your company is worth, based on how much they're going to buy and what percentage they're going to own. That has nothing to do with the valuation that is actually going to go on your common shares, which is often a 409A valuation, which is something that you should go and get a third party to do so that you don't ever have to be the one who stands up in audit and says, this is why this company is worth this much at this time. Your 409A will often be dramatically different than the valuation of your company in the private market, which is what you can convince investors to do. And that's a good thing. Keeping your 401A valuation low allows you to continue to grant shares or generally options by the time you get there to your employees with a very low strike price. So if things go really well, everybody can benefit. But a lot of founders get confused or sometimes even go off and get 401A valuations from firms and argue it up to try and convince investors that their company is more valuable. No investor is going to look at a 409A valuation and say, oh, this is the value of the company. So 409A is completely separate from the company's valuation in the market. Don't get confused by that. And if you're in the early stages of the company, if you're pre-Series A or even Series A, do not pay anyone for a valuation on your company other than a 409A to just price your stock options. Anybody who's offering that service otherwise is basically just, scamming you. All right, all right, all right. Almost through the phone. Can I issue U.S. startup equities to foreign residents in India? Yes. So you can pretty much issue equity to anybody if you have a US based company. The only thing you want to do is put the onus on them to check if they have to do anything differently. So certain countries have, registration requirements, things like that. Delaware doesn't care. The only issue you might run into is if you have what's called a beneficial owner, which is somebody owning more than 20% of the company through equity, you have to report that in various transactions like opening a bank account, or doing other kind of financial transactions. So if somebody is a foreign owner, that might complicate that, because certain institutions, just don't allow companies with foreign beneficial owners to do business with them. Uh, Nikisha, there will be a replay of this. We will send this out tomorrow or over the weekend. My email address is nashagus.com. Hit me up if you're interested in converting an entity. I will introduce you to Robert from our team. Uh, Sujitra asked about Wyoming. Wyoming, very interested. Wyoming made a play hard at Delaware in the middle of the crypto craze to try and establish itself as a state that could make money off of incorporations and filings. So Delaware, 25% of their state income comes from franchise taxes on corporations and LLCs. So it is a substantial revenue driver for a very small state. You could see other states wanting to get into that. Wyoming made a play. What they tried to do, the biggest thing that they led with was, corporate friendly governance, very similar to Delaware. But they also made an LLC available that could wrap a DAO, a distributed autonomous organization, that a lot of people were trying to start in the crypto craze. A lot of that has died down. You'll hear some mumblings and rumblings about other states and things like that. A lot of times people will get pushed to incorporate in a state a local state because they think it is required to get some kind of benefits from the state, usually like grants or things like that. Often, all it takes is foreign qualification in that state. So you can start a Delaware C Corp, foreign qualify it in the state, and still make use of all the grants and things like that. I have seen a couple that legitimately require a state-based entity, and you really just have to do the gamble of like, how big am I going to make this? Am I going to have to convert it anyway? Are these grants worth it, etc. But I think Wyoming has died down quite a bit in terms of trying to be the leader. Texas is making moves for it at the moment, largely on the behest of Elon Musk and all that insanity. So far, the Texas courts just don't have enough case law on the books to give investors confidence, unless your company is headed by one of the richest men in the world, or a billion of revenue kind of thing, which changes the game considerably. If you're a small startup, you probably don't want to play in that space unless you know it. Do 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 do. Logan, I think we covered a little bit of this. You incorporate in Delaware 10,000 shares at $1 par value. You can fix it. So it's not really a stock split. What you would actually do is you would file a charter amendment in Delaware, which is going to cost you about 450 bucks. But it literally just like finds and replaces things on your COI where you can say, oh no, we didn't do 10,000. We did 10 million. Oh, and the par value wasn't a dollar. It was a tenth of a millionth of a dollar. You follow that, you get it board approved. Hit me up on the email. We actually have some templates for that that can help you out if you're going in the high growth way. So you don't need to do a stock split. Instead, what you do is you basically amend your charter to say we have 10 million shares now, and the par value is much lower. And then you can just issue new shares to get to the ownership balances that you want. Yeah, Nakash, your experience is quite common. A lot of investors, especially angel investors, are state specific or regional specific, where they want to engender and encourage economic activity in a place they generally have, some kind of affinity to. There are just straight up return based investors who will invest in anything. If the business looks good, if it's growing, and they could get a return on it, they're in. But there's a lot of investors who their sole motivation is to drive economic activity in a place they love. Like we have our CEOs in Nashville. Nashville is actually a burgeoning ecosystem at the moment. There's somebody there named Zap, who is her name is Haley, but she goes by Zap because her last name starts with Zap. Her entire focus is to just drive innovation into Nashville-based companies. So, like, literally, thesis-based is if you're not a Nashville-based company, I'm not investing you. Does that mean that all their corporate entities are Nashville? Not at all. They're all Delaware C Corps, but they live in Nashville. They hire in Nashville. They create economic activity in Nashville. The founders live in Nashville. She can bring them together in person. She can run events. And that is actually very common. Something that we actually encourage in Gust is trying to activate new angels in ecosystems outside of the coasts. So the Valley and New York have been one of the largest places and continue to be the largest places of innovation and startups and things like that. But we don't think entrepreneurship is unevenly distributed. We just think it's where the money has gone. And so we're trying to encourage groups, investors, founders to really tap into those ecosystems. So you'll definitely see some regional focus on investors, ourselves included. Um, Tochiwa, if you need help raising capital, I think I still have it up on the screen. Just jump into Mission Control. I'll give you a free invite to one of our office hours or something like that, and we can really help frame you. The nice thing about Mission Control is we have a whole asynchronous curriculum that you can go through at your own pace to really just open your eyes to like, am I building the kind of company that actually warrants angel investment, or should I be looking from investment from different sources? How big is this going to be, et cetera? Da, 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 da. Yeah, the repurchase clauses, that is vesting. And the most important thing about it, as you highlight there, is nothing, it's not that nothing proactive needs to be done if somebody leaves. It has already been done proactively. So they have pre-agreed to the repurchase right. So when they leave the company, you can literally type as simple as a email that just says, you're no longer with the company. We're, enacting the repurchase right based on your vesting schedule. They don't even have to approve it. On Gus Launch, you literally click three dots and repurchase unvested shares, and it just happens. No approval, no emails, no signatures, because it's already been pre-approved in the stock grant. And Angelina Ning asks, how do you determine the par value of your company at the time of incorporation? You make it up. It's usually zero. Par value is the lowest price in which you're allowed to issue a share. So it is not technically the value of the company, but when the company starts out, intuitively it is worth its par value. But you literally just make it up. So we set it at four zeros and a one. That is the most common in the industry just because it makes everything super cheap and it makes the math easy. You could do three zeros and a one, you could do five zeros and a one, doesn't really matter. But as silly as it sounds, because you filed a piece of paperwork that said this is the par value, that is the par value. You're not valuing the company in terms of what you think it's worth, what you think you're putting into it, what you've already done outside of it before you assign it to it. None of that. You're literally just saying, hey, I started a new company. Each share is going at, a tenth of a millionth of a dollar, and so be it. Let's get to work. And if we increase the value of it later on, we'll talk about the value, but you don't really have to do a lot of thinking around setting that number. All right, last question here. Do I have a source to see which area has the best ecosystem available for launch? It depends. Depends on your company, depends on what you're doing. I will say, the Valley is a bubble. New York is a bit of a bubble. In terms of like you literally we used to have an office in New York, and you can't you can't walk out of your office without like running into a startup event. Oh, a law firm with a VC is doing a thing at this bar. Oh, there's a lunch and learn over here. Oh, so and so is doing a talk on this. So city ecosystems do tend to foster and cultivate entrepreneurial activity. Nashville, Austin, they're up and comers. Boston is another one in the US. I know Toronto actually has a pretty cool startup scene in it. But depending on where you're at and what your product is, you can be strategic about it. So I know that specifically Toronto actually has some really decent grants. I have a founder that is a Delaware C Corp, but moved to Toronto, moved their headquarters over there, qualified in that because they could get a bunch of grants and because their family was Canadian. So they had some roots there that made it work. The Delaware, Pennsylvania, kind of like Boston Triangle is actually really good for med tech and physical devices. There's a lot of ecosystem accelerators and investment interest in those kind of industries. So that might be very different, from something like Arizona or even Austin. So really looking at, what you're trying to accomplish, what the industry you're in, and what sort of resources are there, might put you in different places on the map. It's increasingly a digital and virtual world, so you can have a lot of spread. I know a lot of New York City based founders who moonlight as Valley based founders, which by that I mean they just travel over there all the time so that they can get a lot of face time in the Valley events, if they're going at that kind of funding round. Another thing I will say is the expectations, the appetites, and the motivations for investors in different localities change. So one of our, I should have mentioned them here because usually they sponsor this event with us every week, but Forecaster, they're a Kentucky-based company, which is crazy, if you would think about it 10 years ago. But there's an ecosystem there, and their VCs and their investors and their angels want that money to stay in that area. So they want them to hire people in that area. So you might find yourself with, different kinds of conversations, both positive and negative, based on the location you're going after. And the appetites and the prejudices are very different. We just came back from an event in Nashville, actually, with InvestTN and 3686, which is an organization around there. That's a burgeoning community, and a lot of the people there have an appetite for not just like, you know, I'm an old punk kid, so like not selling out, right? Just going to the valley, raising a ton of money from A16Z or Sequoia and being like, we're a big startup. So you can hedge your opportunities and your bets if you look at, uncoveted places or new places. But also the capital is a bit more limited. Somebody can get, a couple $1 million checks from a Sand Hill VC in a way that you might have to go and talk to 20 Kentucky investors to fill out your round. So it's you know, you weigh your odds, where your specialty is, and where you want to be as you build a company. All right, I got through all that. Thank you, all for hanging out for a little extended Q&A. I know I am verbose, and Pete could have done this presentation in probably half the time, but check us out. Gus is super cool. We love doing what we do. We're helping founders out no matter, every walk of life. And we have a bunch of cool tools to support it. And I threw my email in there again. It's nash@gus.com. If you have any questions, if you have a company that you want on board, just let me know. I'll point you in the right direction and we'll hopefully help be a small part of your startup success. Have a great rest of your week, everybody. I'm sure I'll see you again within a week. Thank you very much.